Yes, Miss Knight. Sorry if I got a bit tetchy towards the end. I obviously needed my lunch. I hope you got some. Yes. So can I just summarise where I think we got on 1A? I just wrote it down for myself. Now I've got to find it. Yeah. On the generic point about whether whether the SOP amounted to a policy, you adopt Mr. Drabble. Yeah. On the particular point about whether you were disadvantaged by the non-disclosure of that policy, if it was one, yeah, you say that although aspects of the appellant's mental health were considered for the purposes of the decision of the 5th of July, that was not in the context of the policy, if that's what it was, because if you had been aware of that policy, you would have deployed it in order to get released from detention earlier, and thus ceased to... Sorry?
To that end, to the end of coming out of the priority.
Yeah, well, that's what I'm saying. You deployed it to get released from detention, and thus ceased to be eligible for transfer, at least at that date. Yeah. That's the point, is it?
My Lord, that is
okay, that's helpful. I suppose one question one would ask about that is, surely if you had grounds for being released from detention, you would have deployed them anyway, irrespective of its consequences for removal to Rwanda.
The claimant did make representations for release from detention, but because of that on the 8th of June, without being aware of this, the SOP and its relevance to being in the Rwanda cohort, in those terms. But the Secretary of State's response was because of the proximity to removal.
Yes, I see.
So it is a circular point.
I see. That's the point you were making.
So he meets the adults at this level too, but because he was going to be removed, then it was found that he wouldn't be released from detention. So you say there is still an unfairness there, and that's the steps we set out in our paragraph 32A to...
Now, all this gets you nowhere as regards actual liability to removal, because that decision has already been quashed. But you say it also ought to be a ground for quashing the inadmissibility decision. That's why you're still persisting in this. Yes. Is that right?
Yes, because we say that the original inadmissibility decision should have been quashed because we weren't told about the criteria as they operated.
Why would they? And they would have gone to inadmissibility because.
For the same reason that if we'd known that the SOP was the operative part of the operative criteria for inadmissibility, we would have made representations on them.
But hang on, would they have gone to inadmissibility? Surely the SOP would only have gone to the second decision, the decision whether to transfer.
Well, yes, there's the structural part of the decision. I don't want to take too much time on this, but the structural part of the decision, and Mr. Vial, Mr. Sheldon, and the Secretary of State's response adverts of this, which is to say that you don't get on to discretionary consideration under 345B2, which is part of the rule structure, unless your claim has been deemed inadmissible.
Right. But to be denied the opportunity to make submissions on something that doesn't go to admissibility in the first place isn't a ground for quashing the decision on admissibility.
The decision is headed inadmissibility and removal.
Yeah, but they are two distinct decisions. Everyone accepts that.
I do accept that they are. We were obviously about to be removed in the initial stages, but it's quite clear that the question back to the question of suitability for inclusion in the MEDP. That's what the standard operating procedure goes to. Which is,
yes, I see. So it does go to inadmissibility. But which provision of the MOU?
It's back to the standard operating procedure.
Yes, but that doesn't help you. Inadmissibility is based on the MOU criteria, isn't it?
Yes. Well, it will be the
No, sorry, I'm being slow. It isn't.
It's 345B and 345C, and so if 345B is to be the application of 345B and who gets put into this procedure under the rules, the SOP is recognises, as the court do, we can't send everybody potentially to Rwanda. Rwanda hasn't got capacity, so there's a prioritisation cohort, and so it's that which is, it's still a discretionary.
Yes, I know, but I'm on a different point now. I'm on the point about what you've already won on your individual circumstances about being moved to Rwanda, but you want a bigger win because you want to cross the inadmissibility decision as well. What I can't, there may be a very simple answer to this, but if so, you must give it to me just in a sentence. Why would being vulnerable, if that was a criterion, have gone to inadmissibility as well as to decision to transfer you to Rwanda?
Because of the terms of the SOP are that who's going to be referred into the MEDP, which
No, but the MEDP's inadmissibility's got nothing to do with Rwanda. It's got to do with whether you satisfy. Or am I missing something? You're full of this, and I'm not. But
well, my lord, if I
can I just pause that? Am I making a bad point, Mr. Sheldon?
No.
Right. Okay.
Right. Okay. Well, the inadmissibility and removal decisions are taken pursuant to the immigration rules and the policy. 345A is: have you made a previous claim for asylum? That's my client. And then 345B is there a safe third country for the particular applicant? And then the criteria are in relation to, is the refugee convention.
But sure. Okay. Well, we better look at this.
The rules are set out at paragraph 11 of the judgment.
Yeah. I thought I had all this.
And the short point.
Wait. You remind me why you satisfied 345A.
Because we had made a previous claim for asylum in Greece and been granted.
But which? Okay, wait, but which is that?
So that is 345A2.
No, surely if a previous.
3A, sorry, 345-3A. We've already made an application for asylum protection in that country. But the Secretary of State isn't proposing to remove us to that country.
Well, that's a separate point. So, to show that you were had vulnerabilities in the sense of the mental health conditions we read about, wouldn't go to inadmissibility at all, would it?
Well, my lord, if I can just, if we look at the way that of the structure of rules, and this is the point, Mr.
Well, I am looking at the structure of the rules. I'm looking at
The point Mr. Sheldon takes in his response is that exceptions for the admission of inadmissibility to the UK, the exceptions for the admission of inadmissible claims to the UK asylum procedure set out in 345D, and it's when an application has been treated as inadmissible and either removal to a safe third country within a reasonable time is unlikely, or upon consideration of the claimant's particular circumstances, the Secretary of State deems removal to a safe third country is inappropriate.
Yes, I see. So the answer is 345D2.
Which goes to discretion and the relevance of the operative.
Well, not really discretion. Well, I suppose.
Well, the operative criteria, which is.
So you say that the fact that you had mental health difficulties would, or at any rate might, have affected a decision under 345D2.
Yes, because of the SOP saying that certain groups of people, including those with significant vulnerabilities, would not be referred into the
That seems a non sequitur.
My lord, if you look at if I can just look at the SOP.
Remind me where it is.
So in my bundle, it's just been added at the end, 214 of the supplementary bundle.
Okay.
Well,
I looked at it somewhere else, but I've got it now. Yeah.
It was in Mr. Drabble's bundle also.
Yeah, I've got it.
Yes. So the SOP.
So I haven't got it.
No.
Where was it in Mr. Drabble's bundle?
I think it was is it 27?
I found it. Okay. Yeah. Yes, I think I have. Yes, I've got it.
Yes. So it says this is the question for the caseworker. So under the third box down, referring small boat arrivals into detained asylum casework and the MEDP. At the bottom of the page, certain individuals arriving by.
Sorry, which page are you talking about?
Bottom of the first page of the SOP
Yeah.
hasn't got internal pagination. At the bottom of the first
Yeah.
page, under the heading background, certain individuals arriving by small boat in the UK may be suitable for detention.
Yeah, you don't have to read it out. Yeah, I've
Yes.
got it. Yeah, what's the
So,
point?
and then over the page, this is the part Mr. Drabble took you to. Additionally, it's about under the third indentation. Additionally, certain individuals arriving by boat may.
Well, exactly. That's my point. That is a 3, 4, 5 C question, isn't it?
The bottom part of it is how significant vulnerabilities. It's the 3, 4, 5 C is when an application is to be treated as inadmissible, the Secretary of State will attempt to remove to a safe third country which may agree to their entry, and then she has the exceptions as to how she will operate that in practice. So that's the SOP demonstrates that there is criteria. Cohorts of persons who won't be included within the removal, into the MEDP on the basis of their vulnerability. That's how
I've got all, exactly. I've got all that, but that's the bit on which you've already won. You're not going to be transferred to Rwanda until a fair procedure has been gone through. But I thought the whole point of your running these arguments is you want a bigger win, which is to win on the prior question of inadmissibility. Have I not got that right?
My lord, that is correct.
But I haven't quite understood how this. Well, but I think perhaps I might have explored it with you enough. At the moment, I don't quite see how this goes to inadmissibility. But I.
Well, the referral into the MEDP isn't simply confined to the question of whether we have or have not got a human rights claim, bearing in mind, of course, in this case,
And don't confuse matters with the human rights claim.
Yes. But the only question, perhaps just to bring it back to the short point, the only question that is addressed in the 5th of July decision, which is claimed to supersede the early decision, is what vulnerabilities the claimant might have in Rwanda engaging with the RSP process, and doesn't engage with what we say is the correct question of whether he meets the SOP criteria. And that's all we can
All right, thank you. Well,
say more than that.
no, okay. Well, let's move on to ground 1B.
So ground 1B is perhaps it's an aspect of that which is about whether he had appropriate time frames. In short, we say we weren't given appropriate time frames.
Well, I know what you say. I was really what I was asking you about was, or I was about to ask you about, to be fair, because this is how I've tried to structure this, is the answers to the points made by the respondents in their para 19 representations, which I analysed in my order as 3 points. One, that the relevant date is the 5th of July, by which time you had ample opportunity to make representations. What's the answer to that?
Say that the reasons the brief response is this isn't a replacement decision. It builds on the early decision.
Yes, I see. Okay.
And it takes account of the criticisms that were made about the medical evidence being produced at short notice. Those are all part of the fairness point, which in some ways are echoed by the asylum aid grounds in a more general sense.
Okay. That the issue is academic, since the questions on which the applicant says you didn't have the opportunity to make representations will have to be reconsidered in any event. What's the answer to that?
Well, we say that the starting point of that reconsideration is going to be whether this is a lawful decision or not. So
I wouldn't have thought so. Why?
Well, this is we are the only claimant left decision before this court because everyone else's decision was quashed.
Oh, I didn't know that.
Yes. So all of the other individual decisions, both on human rights and in this instance, whereas this claimant, for reasons to do with his particular history, under what he...
But because of having claimed asylum in
Yes,
Greece, I see.
For those reasons, the Divisional Court declined to quash the inadmissibility decision.
Yes,
So,
I see. I'm sorry, I hadn't picked that up.
Sorry, apologies. RM also hasn't. Sorry, but all the other claimants do not have.
That's helpful. And then C.
This is a short point, which is that the Secretary of State relies on the fact in the 5th of July decision letter that she has committed to providing Rwanda with notification of any medical needs.
No, sorry, this is round 1C. I'm so sorry. It's my fault, or it's confusing. Under ground 1B, I broke the Secretary of State's points up into 3 points, which I call A, B, and C. C, that the representations are irrelevant to any questions under 345A or 345D. It's really the point I was putting to you before. It doesn't go to inadmissibility. That is the point, is it, Mr. Sheldon?
Yes.
Yes.
I will re-say that if taking the decision as a whole, inadmissibility is 345. It's treated as 345A to D, and D2 is where the discretion on the particular circumstances is material. The Secretary of State saying, well, it's a discrete process, 345B and C, and then you come to D if you're found to be inadmissible. But when you look at the inadmissibility guidance and the decision letters, you don't see that.
Yeah. Okay. Well, that's really the point we've been over before, isn't it? I think. Right now, ground one. Your ground 1C.
My 1C is a very short point, but it's to say that Secretary of State in the decision.
Well, I know what the point is, and the Secretary of State says there's no obligation to you to disclose the medical condition to Rwanda. There's an obligation under the MOU, but that's an international obligation.
Yes, and she in the decision letter of the 5th of July, she relies on that at 697. We've committed to providing them with notification, but on the only evidence we have, and shortly before the claimant was about to be removed, the only documents we have which we...
Sorry, no, just give me that reference referred to in the decision.
At 697,
she says,
in the MOU, the UK is committed to providing Rwanda with notification. And on the only evidence that we have in this case, shortly before the claimant was about to be removed, before the notification of to Rwanda and the acceptance form made it clear that there was no such notification. There's a criteria. Does he have any medical needs or criminal convictions? The answer was no. On the form, that was on that basis that Rwanda accepted the claimant, but in fact, on his particular...
Yes, I had some difficulty finding the form because you gave a false reference to it in your...
It's in the supplementary bundle.
Well, you'll say it's at page 21, but I don't think it is it? That's what...
I think that must be a...
Is it 51?
83, the acceptance of the notification is 51.
Yeah, so it's not a problem. I just want to make sure. So it's a typo.
Yes, I think it's an incomplete reference. So the 51 of SB is the form from the Secretary of State.
Okay, and so your point is there's nothing about it on the form.
No, there is something. There should have. There's a space for it to be included, but in fact there was no such notification in the claimant's paper.
Okay, now how is that a breach of a duty to you?
Well, it's the Secretary of State is relying on the notification as being before this court in respect.
Where's she relying on it?
Well, in the decision letter, she's saying that the MOU in the MOU of 697 made that commitment to providing the notification as part as part of the notification. In the decision letter, she's relying on terms of the MOU to provide such notification. If I'm to demonstrate that...
Hang on one second, I'm just looking at 697.
Yes, it's in the second half of the paragraph under vulnerability.
Yes, I'm just trying to find it. But that would.
The Secretary of State is clearly in this case relying on the terms of the MOU and complying with those terms to satisfy this court that vulnerable asylum seekers will get the treatment or the.
Well, it's not. This isn't a letter to the court. It's a letter to you.
It's a letter to us, but she is, when we're challenging the lawfulness of the transfer arrangements and whether there are sufficient guarantees. On the facts of this case, we can see that what is being said to be a sufficient guarantee that vulnerable individuals, such as the claimant, will have their conditions addressed in Rwanda, such that they're related. It's a short point, but we say on the facts of our case, there isn't anything to show that the Secretary of State did that or was going to do that. And I don't see Mr. Sheldon's response. He simply says it's a non-binding agreement in international domestic law.
Well, that's what I've been putting to you.
Yes, but the public law challenge from the claimant to the Secretary of State's decision is the reliability of the process that she has in place.
Yes, I see. Now, but all this would show, if it happened, would be a mistake in a particular case.
Well, at the point of the Secretary of State hasn't provided any evidence as to why this.
Well, that's because you took the point at a very late stage, and I understand you say it's because you only saw the document at a very late stage.
Disclosed to us on the 5th of September. The Secretary of State has the opportunity to.
Well, can I just understand how it was raised? It wasn't pleaded for that reason.
It wasn't pleaded for that reason. It was raised before the Divisional Court.
Did you ask for permission to amend to plead it?
We raised it before the Divisional Court. We didn't. I don't recall asking for formal permission to amend because the document arose on the first day of the hearing.
No, I see that, but that might be a reason for asking for permission to amend.
But I don't think we formally did ask.
No, okay. Can I just ask? Well, Mr. Sheldon, do you accept that this was raised in oral submissions? We don't.
Yes, I do.
That's very fair of you. But we don't. I'm sure Ms. Knight were told we don't have it. It's never been reduced to writing anywhere.
Not that
as a ground. Yes, I see. And why would it go? Well, we got the same point about whether it goes to admissibility.
Well, yes, it goes to the reliability of the assurances, which is back to what we're saying in relation to how vulnerable asylum seekers will be treated in the Rwandan process. If they're not notified, that undermines.
Well, they weren't notified in your case. The system is that they will be notified. You asked us to infer. You may be on the material available. It's a correct inference.
I can only speak for my own.
Yes, quite. Okay, I understand this now. I'm going to have to take a view about it. Now, ground two is again. You see what the Secretary of State says about that.
Irrelevant. Well, all we say, if I can just back to this point, which is in the inadmissibility guidance. The Secretary of State says it's irrelevant that in another decision which has been quashed, the Secretary of State didn't take proper account of the human rights, the material human rights claim. If I can just direct my lord to the inadmissibility guidance, which is in our supplementary bundle at page. It starts. It's a relevant part is at page 24.
Yeah, I have it.
And so, at the top of page 24, in my copy, apologise, it actually seems to be highlighted in my copy.
Just tell me what you want me to read.
Yes. The second paragraph.
Okay, I'll read the second paragraph. Yeah.
So we say, contrary to the submissions from the Secretary of State in response to this ground, that there is a clear interrelationship between the human rights claim that is made and the inadmissibility claim. That the Secretary of State, that human rights claim in this case been quashed by this court. And so the question is whether there is what's the interrelationship between the human rights decisions and the inadmissible decisions in this case.
Yes, I see. Okay.
And so I've set that out in the skeleton argument.
Yes.
It's particular to our facts. And the question is in relation to the what matters in the human rights claim go to the generic argument, and what factors go to the individual's
Then now let's look at ground 3, which is the Gillick.
Yes, and so I see what my lord has said in the note in the order, and we say the primary submission, and this comes back to the inadmissibility guidance as operated with, as we've seen, the assessment document and the seekings, that it does, of course, it intersects with the Ottoman ground, but what we say is that under 345B and C, the Secretary, for the purpose of inadmissibility, although they are said to be in the context of particular applicants or particular claimants, the reality of the application of the assessment guidance, and I think my lord's already looked at this morning, is that those are generic positions on refugee convention, on the safety of the procedure in Rwanda, and generic positions on the question about whether there be an onward reform under 345B. And so, absent yes, of course.
But what does this add? What does this add to the other points?
Well, the Secretary states what, as we say in our skeleton arguments, invited the court to treat these as very discrete issues. Look at the individual claimants. Look at what happens in their individual decisions, and don't find any generic illegality in respect of the policy. But if the policy invites, or inevitably in a range of decisions, or indeed in this decision, invites an unlawful conclusion, because if you separate out...
Well, okay, I see the point.
The individual particular consideration doesn't save the policy from unlawfulness, because those considerations are to do with, for example, particular medical conditions and so on. That doesn't save the generic argument about the safety of the Rwandan asylum procedures. And then the question is what test should be applied to it, and whether that's modified in the context of A.
Okay, well, I see what the point is. Thank you.
Sorry, I'm happy to.
No, I think that's all I need by way of clarification. I just want to make. I asked you this as we went along, Mr. Sheldon. It seems to me that an important point, perhaps not about all of these grounds, but about several of them, is whether they do go to the question of inadmissibility. And I don't want to make a mistake here. Inadmissibility depends on 345A and 345D, effectively.
345A.
345A, all right, but then there are exceptions to inadmissibility which come in at 345D.
Well, once inadmissibility has been determined, there are some provisions at 345D.
Well, that's a funny way of putting it, because the effect of them, all right, once it's been prima facie determined, it may be taken out of inadmissibility by 345D, or was that not the right way of putting it?
Well, 345D says when an application has been treated as inadmissible, and then one of two considerations apply, the Secretary of State will admit the applicant for consideration.
Well, so effectively won't treat as inadmissible. I mean, like all these rules, they're not beautifully drafted, but the net effect is that they're not inadmissible if they fall within one of the exceptions.
Yes.
But so we look at 345A and 345D, but beyond that, we don't. Some of the sorts of questions which have been relied on about vulnerability and so forth would be, if they didn't get caught by 345A and 345D, would only come in at the second stage, which is, are you going to move them to Rwanda?
Yes, because the SOP, I mean, I won't repeat
No, don't
about
repeat
what the
it.
SOP means.
Yeah.
The SOP expressly says relocation to Rwanda.
Yes, exactly. So, but by definition, that's where you would say where an inadmissibility point's already been established.
Yes.
Okay. Thank you very much. I think I've got what I need to make a decision about that, though I'm not going to make it now. I thank you for your help this night.
Just in response to Mr. Sheldon, if I may, just with my Lord's note, paragraph 1.1 of the inadmissibility guidance. The assessment guidance refers to that guidance supporting decision makers to consider whether the person whose claim is assessed as inadmissible is suitable for relocation to Rwanda as a safe third country.
Yes.
Within 353B.
But this is a point that was gone over, and nobody is in the judgment, and nobody, I think, is challenging it, at least not in any ground for which permission has been given, that although the decisions are taken, that the decisions are taken sequentially, but they may well be considered effectively at the same time. And that's all that establishes, isn't it? Okay. Right, now, I think we'll take Mr. Gill next, as he can come forward. Can we take your points in reverse order? Because I think two of them, well, yeah, there's three grounds on which you seek permission. Ground 6 is the refusal to allow the evidence of Mr. Mozam. I had not got any of the material on which I could make a decision on that, and I said that I would let you raise it nevertheless if that material was lodged by deadline on Friday, which it hasn't been. I'm guessing, and I'm not surprised, that this is not a point you're pursuing.
I don't have these transcripts, so I'm unable to pursue it.
Well, it's not just the transcript. I mean, well, firstly, it wasn't just that. I hadn't got the witness statement for a start.
I understand your lordship's point, and there's nothing much I
Yes,
can say to
yes. I just didn't want you to think it was okay. And I, speaking for myself, if this gives you any comfort, it didn't look like your strongest point anyway, though I couldn't ultimately tell without seeing the witness statement. Right. Okay. So that goes. Then ground 4 was really just to clarify the position about the generic grounds, which I think, unless you've got anything you want to add on it, we clarified in earlier exchanges with Mr. Drabble and Mr. Hussein. The line, I think, is that you can only pursue the grounds for which you're given permission. But, of course, if, the grounds which you plead and for which you're given permission, but, of course, if they are generic, you'll get the benefit of them. The only practical difference is you won't be able to address the court on points you haven't pleaded. But realistically, the generic grounds have been pleaded by other people, and excellent that your submissions would no doubt be. The ground will be covered by Mr. Hussein and Mr. Drabble and anyone else. So there's probably no misunderstanding, but it puzzled me when I looked through the way it had been put. But we're all in the same place on this.
I believe so, my lord. Your lordship asked a question about the order that you sent us about the relationship between the 5th of September hearings and the subsequent hearings. The position was simply this: we were all entitled to attend the 5th of September hearing, and we did remotely, because we were not expected to repeat what was being said.
Yes.
And we therefore heard what Mr. Hussein and others were saying, and I told the court on the 12th of October I wasn't going to add to those sentences, because that said everything I would.
No, that's fine. There's no criticism of anyone. But to me, coming to this cold, one of the first questions I asked, I thought to myself, is why are these generic points not pleaded in each case? And the answer is everyone has taken the practical position that if they're truly generic, you'll get the benefit of them whether you plead them or not, and they are pleaded by the people who are going to argue them. So that's fine. Right. So that then really brings us to data protection. Now, I have looked at this carefully, and it seemed to me that the correct approach was this. My starting point must be, because this was the Divisional Court's principal reason, whether it was correct to say that even if the impugned decisions involved breaches of the data protection legislation, that didn't make them unlawful in themselves. And that seems to me to be the big point at the permission stage, because that, after all, is the basis on which the Divisional Court decided it. I think I would, however, say that if that was arguably wrong, I might be minded to withhold permission if I was satisfied that with one of the points on which they dealt with very briefly was nevertheless a real knockout point. Because now the only one, the moment where I'm thinking that might be the case, is for Article 49 1D, if I've remembered correctly. The others I don't think could be described as knockout points. Certainly the one about Article 13 isn't, because the Secretary of State themselves thought it, the Divisional Court themselves expressed some doubt about it. So I would invite you to focus on the main point, but I may ask you about Article 49 as well. By the main point, I mean the Divisional Court's point that it doesn't matter if they're breaches, because that wouldn't undermine the lawfulness of the decisions. Does that give you a steer as to how I'm approaching this?
Yes.
Thank you.
Well, in relation to what your Lordship calls the main point, we say that the decisions by reference to the data protection legislation are absolutely essential to making any decision under and for the purposes of the MEDP/MOU.
Well, I wondered, I'm sure you say that, and I'm afraid I'm going to do what I did brutally to Mr. Hussain. I'm not going to allow you to develop submissions. I've got a very full skeleton argument. I know what they are, what the arguments are. What I want to do is go through the actual reasoning of the Divisional Court with you, if I can find it, and just test you on one or 2 points.
Yes.
And it's paragraphs 1, 3, 4 following. And they start with a point which I see why you don't like, about, it says, matter of principle, it can't be that any breach of any rule occurring will necessarily affect the validity of a public law decision. Sorry, I've garbled it. Any breach of any rule occurring in the context of a public law decision will necessarily affect the validity. And they give an extreme example, and you're right to say it is an extreme example, of someone who's assaulted on their way to whatever the example is. I think perhaps you're being slightly unfair to the Divisional Court. I don't think they were suggesting that was like this case. They were merely making that point to show that it doesn't invalidate the decision in every case. And what they're really saying, I think, is that you need to look at the integralness of the data transfer to the particular decision. If it's integral to the decision, it's a phrase they use in 135, then if it's unlawful, it will breach the decision itself be unlawful. If it's not integral, it won't. Can I pause? Are you satisfied with that as an approach?
I don't mind that as an approach for the purpose of the discussion your Lordship and I are having. I'm not sure about the word integral.
Well, it's important you say your own word. There's got to be some sort of degree of connection.
There has to be some degree of connection.
But what word phrase would you prefer?
Well, if the decision is relevant to, if the decision is a sine qua non or a essential prerequisite to, I think those are the two tests, really. And in these cases, it most definitely is.
Okay, well,
set out in our skeleton argument.
Well, let's just then go through Perhaps, again, sorry, I'm just doing this rather dialectically. Mr. Sheldon,
I'm afraid it's not Mr. Sheldon on this, it's Mr. Hopkins who's going to make
Mr. Hopkins, well done, Mr. Forgive me for not knowing it was you. I should have done, because I think I got your note on it somewhere. We needn't quibble with particular phrases, but the broad approach, have I understood correctly what you understand to be what the Divisional Court was doing? It was saying how integral or how relevant, what degree of relevance has it got to the public law decision?
Yes, Lord.
Yeah.
That's exactly what we say the approach was below.
And I think it's also what you say it should have been, therefore. Yes. Okay, that doesn't surprise me. So we've got a degree of common ground there. So then we've got to look at each decision. And I know you've identified in yourself an argument 5 or 6 decisions. It seemed to me, with respect, that analysis was slightly overcomplicated. They've identified 3 decisions. No, I'm sorry. They have structured it by 3 breaches, and then in context of each breach, they look at at the relevant decisions. So the first one is the breach of Article 35. That's the need to carry out a preliminary assessment. And what they say is that the failure to make a prior assessment of the kind required by Article 35 isn't integral to the impugned decisions in this case. And you, I think, say it is, but I'd like to know why. It does seem to me rather distant.
It's not. The reason why it's not distant is this. In order to decide whether a third country is safe for a refugee, in order to decide also whether it is reasonable or lawful to remove a refugee to that safe third country, whether reasonable or lawful under common law rationality type arguments or under ECHR. In order to do any of those things, and those are 345B and 345C questions that I've just mentioned, in order to do any of those things, you've got to make an assessment of that foreign country. That must be basic. You do that assessment in a number of ways, not only for all the reasons that Mr. Hussain and others have pointed out to you, but you also do it in terms of looking at that country's data protection policies and practices. It is not for nothing, therefore, that when the UK GDPR sets out a structure of the tests that you must apply if you're going to send data out the EU to another country, it starts off in Article 44 and 45 2A, which your Lordship will have seen in our process, by specifically referring to the human rights situation generally in that country. And it then sets out a structure by saying you must make an adequacy decision. But before I deal with that structure, but to focus on the point your Lordship says, this is why when you get cases like the EU-Canada agreement case, can you even give the airlines the personal data? What will happen to it if the Canadian security agencies get hold of it? What are the protections in place for all of that? Or you consider a case like Schrems, can you let Facebook actually transfer all the data from the EU to Los Angeles or whatever their servers are over there? Will there be protection systems there which will ensure that the US security agencies don't get their hands on that? What are the systems that are going to be in place? What the European Court of Justice has said, and this is where, with great respect, the court didn't appear to have looked at Schrems before they came into court, but I'm sure they did afterwards, of course. They don't really appear to have focused on any of the submissions in Schrems. I can take you to Schrems if you...
No, well, I've looked at it. To be fair, I haven't looked at the whole thing, but I've looked at the head note, and I've looked at the passages you quoted.
Yeah, and basically, you may recall that what happened is that there was under a 2000 agreement, data used to be sent from the EU to the USA and vice versa. Mr. Schrems didn't like this. He brought an action because he thought, in the first case, that this data isn't really safe from the prying eyes of the security agency. He therefore brought an action. That resulted in the structure, the safe harbor principles being quashed by the Court of Justice. That resulted in a new privacy shield decision, which then in Schrems number 2, they said even that decision is unlawful, which then led to because it failed to make adequate inquiry into the protections that would be available in the US, which had to be in a manner which was equivalent to the UK GDPR. We apply that approach because we're bound by Article 71 of the Withdrawal Agreement to ensure equivalence. We therefore have to ensure that Rwanda will treat that data exactly in the same manner as the EU GDPR and now the UK GDPR does. You therefore have to make an assessment of the safety of that data. And the safety of that data is there, particularly in an asylum context case. It's all set out in our skeleton argument on page 9 under the para E. The way in which the third country treats that data, you can see how in a 345B safety of Rwanda case, or should we really be removing?
Well, let's just be clear about this. The data which is disclosed at the moment of the agreement to accept is extremely limited.
Yeah.
It's, you'll have it at your fingertips, but it's basically a name, country of origin, photographs, and that's more or less it. If they are then transferred and there are matters relevant to their treatment, such as health conditions and so on, those may be given as well. I've got the exact details in the judgment, I just haven't got them in my head.
It's deeper than that.
But,
I know what you're saying. I think I anticipate it's not as straightforward as that. Because you don't have the evidence, and they didn't go into the evidence in the judgment. The question is, what then happens to the data? Into whose hands does it go? We know it goes to the DGIE. The documents in the AAA supplementary bundle will show that the DGIE then enables that data to be looked at by the Refugee Status Determinations Committee, on which sit a number of individuals who have got nothing to do with asylum determination, but are very, very much involved in all sorts of other government departments, including security departments. There is no information as to what happens to the data that is then given to them. Where do they cart it off? These meetings, and this is in Mr. Botnick's evidence as well, I can give you the cross-reference.
No, I get the point, I know.
But the point is that who knows where that data then ends up? Article 48 of the data of one of the Rwandan laws that we footnoted actually permits them to transfer data outside the country to another body. Now, we have no way of enforcing or seeking any guarantees on what it is that the data, the Rwandan authorities will do in relation to that. Moreover, when we end up there in Rwanda with this data, where are we going to actually make any complaints to? The data law in Rwanda was hurriedly cobbled together, put on the statute book in late 2021 because of this pending agreement. It is not even yet fully, it's got a 2-year rollout period, and if you were to cross-reference all the evidence in our bundle, there is not even an independent supervisory body. Complete breach of Article.
Okay, well, I have got all the points in your skeleton. I'm just trying to probe how the deficiencies that you say there may be in the Rwandan data protection regime are relevant to a decision whether or not to transfer?
Because you would want to be sure that having carried out a proper data protection impact assessment and a proper inquiry and so on, that this person's data rights, as protected by the UK GDPR in accordance with the Schrems standards, will in fact be protected there. Because, for one thing...
But are you saying it's always unlawful to remove to a country where you can't be sure that the basic information about someone, then name, photograph and so forth, may not be, which is given to the country as part of the transfer process, may not be protected?
I am indeed. That's why.
But why then, when we remove people to Jamaica, say, or why is this not a crucial part of the of the decision in those cases?
It is because
well, you may be right. But I've never seen it raised in any case.
Well, nobody's thinking about the issues. Frankly, this is nobody's reading the judgments and understanding why did the Court of Justice say we can't let you give all these information to the airlines because we don't even they won't even that extent. Why did they quash the arrangements between the EU and the US agreed by the European Commission? And said, this is not acceptable, and make them go through the whole process all over again because you can't be sure whether. Now,
is there any case in the EU case law which says that you cannot remove to a country outside the EU data protection regime unless they have equivalent data protection which will protect the data which is inevitably given to the government at the point of transfer? I'm not aware of it.
If you mean remove a person,
yes.
We haven't got to that stage yet. We haven't had that situation yet. What we've had...
Well, EU countries must be removing people regularly outside the EU when their asylum claims fail.
Well, Lord, the reason why we haven't got that, because Mr. Schrems only began raising these points and the Court of Justice only began dealing with these in recent years, the 2015 decision followed by the 2020 decision. All of this caused a massive logjam in transfers of data to the USA, which is why President Obama had to make comments about it in meetings with the EU and so on. It's that important.
Just hang on 1 second. Yes, I was just reminding myself, as we were at cross purposes, Schrems wasn't a case about someone being removed.
No, it's about the data being removed.
No, I understand that, but this is a completely different context.
No, it's not.
Well, the context, let us take a case of someone being deported. I appreciate, of course, these are asylum seekers, they're not being deported. But just to make it straightforward, to take a situation we're all familiar with, both EU countries and this country regularly deport to countries which are outside the EU. There are various limits on their rights to do so. Can't be there if their Article 3 rights won't be respected, and so forth. I've never seen it suggested that it's an essential part of the inquiry. Oh, sorry, the other thing I have to say. In order to do that, you will almost certainly wish to notify the country to which you're returning them.
Indeed.
Mr. So-and-so, here's his passport, here's his photo, here's all the stuff we know about him from here, has been convicted of a criminal offence here, and we are removing him to your country, we're deporting him to your country, and that information goes back to that country. Is it the logic of your position that we can't do that unless we are satisfied the data protection regime in that country is satisfactory?
If somebody takes the point and is, then that would be the case.
Okay. I agree. That does seem to be the logic of your position, and it may be right, but I haven't come across it before.
Well, my lord, with respect, just because nobody's actually thought about these points yet, doesn't mean it's a bad point. And it's much more important, of course, in this particular context that we're dealing with, in most cases, people often say when they get to that stage, dealing with the example you gave, well, I'm not concerned about that, and I don't have any argument that data protection in Jamaica is unsafe, for instance. And consent often goes a long way in these matters. But where someone doesn't consent, of course, then an issue does arise. In relation to safety issues, where we're talking about questions of sending someone to a country where he doesn't want to go, which is very repressive in terms of its freedom of speech of journalists and so on. This was part of the evidence we tried to put in, but it perhaps doesn't matter because the Divisional Court did accept in other parts in relation to Mr. Hussein's case that there is evidence showing that they are freedom of speech is not is stamped on and so on, and there is concern about whether the regime is repressive or not. In that sort of context, bearing in mind that there is evidence also contested or otherwise, what may happen to the data.
I'm going to cut you short, Mr. Judge. These are all points made in the studies, and I've got them.
Yeah.
And you say that for that reason, the breach of Article 35 is integral to the decision to remove, because Article 35 is designed to ensure that you're fully informed before you make such a decision.
Article 35 is designed to ensure that you make the full assessment.
Yes, well, that's what I mean by fully informed. You assess something in order to... and Article 13 is the other side of the same coin.
Tell the person
you
can object. And what you'll recall from the open rights case, because you must have looked at the structure of the UK GDPR, there's a right to object before the transfer occurs. In this case, in SAA's case, they said...
My point is not about whether there's been a breach, which there was obviously some, even the Divisional Court was not happy about. My point is about whether it is integral to the decision, and that's relevant to the decision, if you prefer your phrase. And I just want to understand your case on that, but I think I have already understood it. The purpose of notification is, for all the reasons you said, that people may not be happy with their data getting into the hands of this repressive regime, and therefore they want to be able to
say something about
it. Okay, well, I've got the point on that. Now, and then last and not least, on this question of relevance or integralness, you would say that compliance with Chapter 5 is particularly important for essentially the reasons you've already given me. It's not a different point.
It's a more fundamental point, because this...
Well, 35 is designed specifically with third countries, which Article 13 and Article 35 aren't.
Yeah, Chapter 5 is designed specifically with third countries.
Yes, quite.
In mind, and it sets out a structure.
Yes, well, now let's just come to that. You have one submission, which I've got, and I'm not inviting you to defer that, because, as I say, it's a very full skeleton argument. You say that the structure provides, first of all, for adequacy regulations at EU level or now UK level. Failing that, under Article 45, failing that, safeguards under Article 46, and that Article 49 only applies where it is... Well, I'm not quite sure how you put it, but effectively it's the third in the pecking order. But you're not saying it can't be invoked where there are no adequacy regs and no safeguards, because otherwise it wouldn't have any...
No,
you are saying that.
No, I'm not saying you...
But you're saying that it must be read in the context of the fact that it's a...
derogating provision. It describes itself as such.
Yes, okay. Well, can we just have a quick look at it? I got it in my homemade bundle, but you've no doubt got it somewhere. And 49.1 is rather oddly structured, but it falls into two bits. There's the first bit which provides for specific conditions,
Yes.
A to G, and the only one the Secretary of State relies on is D.
You'll see A is consent. Sometimes people consent.
Yeah, I know, I understand that. But any of these will do. So D is possible in a situation where there isn't consent.
It agreed.
Yeah. And then you've got a power to do it even where 45 and 46 don't apply, and even where the first half of 49 doesn't apply.
Yeah.
But that it has certain specific conditions attached to it. The transfer is a one-off, effectively. It's my translation of not repetitive. Limited number of people, necessary for compelling legitimate interests, and well, I won't read them all out. And there's a duty to notify the commissioner, so the commissioner can take action if he or she thinks fit.
That's where a transfer could not be based on.
Yeah, I understand that.
45 and 46.
I understand that, but I don't think the Secretary of State is basing it on that secondly. Or if they are, if she is, it's certainly a fallback. It's really 49.1D.
That's right. Which wasn't even mentioned in the DPIA. I'm on the evidence.
What do you mean by this? What do you mean by the DPIA?
The data protection impact assessment.
Oh, I see. Sorry. Yes. Well,
which raises a real issue of virings. The point is this: in order to rely upon Article 49.1D, leaving even aside the points about structure of 44, 45, 46, the point is you've got to identify the legal basis for the transfer. The legal basis for the transfer, if it is now said to be Article 49.1D, one would expect to see that actually set out in the DPIA. It is not. And the court didn't even go there.
Yeah.
They didn't even, because they just didn't hear from me.
okay. Well, can I just look at how the court did deal with it? If you look at 139, this is about the Chapter 5 point.
Yeah.
No part of any inadmissibility decision rested on the transfer of personal data to Rwanda. So failure to comply with Chapter 5 could have no bearing on any such decision. Thus far, they must be right, mustn't they?
Well, no, because the point, as we know from the Secretary of State's practice, the Secretary of State makes decisions under 345B and 345C, and only then, in practice, makes the inadmissibility decision.
Okay.
And so that decision-making process that the Secretary of State goes through is absolutely informed by the need for there to be a legal basis for the transfer. They know this. That's why they put it into the MEDP and MOU.
Yeah. Okay. I've got that. And then they say at 140 to 141. This seems to be the court's analysis that the Secretary of State's presumed breach, we're assuming there was a breach of Chapter 5, doesn't invalidate Rwanda's consent. In other words, the Secretary of State may have a problem as a matter of domestic law having unlawfully disclosed the data, but Rwanda's consent is consent nonetheless. Why is that not right?
Well, the problem with that is saying if there is a consent by another state to take your data, take a person's data, that somehow will obviate a breach of national law. But UK GDPR and data...
No, it's not obviating a breach. The point, you've got to say this impugns some part of the decision. And Rwanda's consent isn't a decision.
I'm not concerned about their consent.
No, but
I'm concerned about the Secretary of State's decision to transfer it. I'm not bothered about their consent. That's not the target of my attack.
No, well, I thought that's what you would say, but you've now said it. Yes.
Well, the Article 49.
I mean, your real point is, isn't a decision that necessarily involves transfer of data in breach of Chapter 5 necessarily unlawful? That's your point.
Absolutely.
Yeah.
And this has got to be relevant to decide making a decision under 345.
Okay, so but if you persuade me that's arguable, then the only answer for the Secretary of State is not to say, well, this is unarguably a case falling within 49(1)(d). Why isn't it? Which is the point made briefly, as they put it, by the.
Now, in order to fall within 49(1)(d), you've got to carry out the assessment, as I said, in a proper way. You've got to make sure you're fully informed of the human rights practices of the country, the data protection legislation of the country. You've actually got to refer to 49(1)(d) in your data protection practices. They didn't, and they focused only on. They referred in passing only to the immigration rules. The immigration rules are not law, and you'll see at Form 49.4. What 49.4 says is the public interest referred to in 49(1)(d) must be a public interest that is recognized in domestic law. And the reason why this is important is that the public interest, you can't just say, oh, there's enough to be a public interest in transfer. No, there isn't. In order to make an assessment of whether there's a public interest in the transfer of data, you've got to actually carry out an assessment which involves looking to see, why do we actually need to transfer this data? Is it proportionate to transfer it? Having balanced all these factors up, shall we make a decision that actually we think it is in the public interest, and we are now therefore going to set that out in law? That is why the structure of the UK GDPR and the Data Protection Act requires this to be done through regulations or something like that. I say primary legislation or regulation, or otherwise, not through executive policy. That is why in Section 13 of the Immigration Act 1999, amended after UK GDPR, after EU GDPR came into force in 2018 and amended again in 2020, that is why Section 13 explicitly says in primary legislation that there is a public interest in the transfer of data to a country where we're seeking to remove a failed asylum seeker to their country of origin. They say because of the existence of 49.
Well, then why isn't that fatal to you?
That's absolutely supportive of me, because what it says is that, what it shows is that if you're now going to transfer, because Section 13 is only dealing with remove to the country of origin, not to anywhere else. If you're now going to set up a regime under the 2022 Act, or now claimantly under the rules of transferring persons, not to their countries of origin, but to say third country, you'd expect it to be in finance or regulations, in law, in other words, not in executive policy. So the court is left struggling with saying, oh, we can drag this out of the immigration rules, which are statements of executive policy. This goes to the heart of the matter of violence.
Okay, I'm going to stop you there because I hope it's sufficiently apparent. I've read your certain argument with care, and I see exactly what the issues are. I'm going to give Mr. Hopkins 5 minutes, and then I'm going to rise, and then I'll hear Mr. Ahmed, which I think will be very short when we come back, hopefully at 3:30, but if not at 3:45, and that will still leave us enough time, I think, to talk about the issues about the main hearing. Mr. Hopkins.
Grateful, my lord. You heard from me briefly earlier, my lord, that the Secretary of State respectfully agrees with the Divisional Court's application of a test of integral necessary
got that.
decision.
But isn't it integral? Forget. I'm not saying I don't think it's arguable, but I think that Mr. Gill's strongest point is probably the one about Chapter 5, isn't it? That is it not integral to a decision to remove someone to a third country, or forget that, isn't it integral to the removal of someone under the Rwanda scheme, the third country, that they will be given personal data.
This is a classic, what I call in our respondents' notice, tail-wagging dog point. Of course, if you're going to transfer a human, you're going to transfer some data about them.
Well, I see that, but you'll have gathered from my interventions with Mr. Gill, I'm puzzled if this is such a extraordinary point. Why isn't it available in a wider range of circumstances, which Mr. Gill says, oh, well, nobody's thought of it yet. But there ought to be a better answer than that.
But the answer, I say, is that the important, though, compliance with Chapter 5 is, it is very much an ancillary issue to the transfer, the fundamental public law decision about whether that person should be transferred to the country in question. This is a point we made below in our skeleton argument. It was in paragraph 710.
So you don't accept Mr. Gill saying this is a point only thought of by the court?
Well, I invite you, when considering your judgments on permission, my lords, to consider the very point we make at 710 of our skeleton below, which is that if the decision to remove a person to Rwanda is lawful, then in order to carry it out, obviously you have to transfer a certain amount of personal data. But I say, my lord, that the tail-wagging dog point isn't just a minor flourish. The logical implications of Mr. Gill's position are, exactly as your lordship touched upon, that every single decision to remove a person from not only the UK but countries across the EU that implement the GDPR would be tainted by unlawfulness. That removal of a human being decision would be unlawful if incorrect or inadequate data protection analysis were undertaken. And I say that would be a very surprising consequence that is not...
So I think Mr. Gill's position is the purpose of Article 35 is to establish that the data protection regime in the transferee country is as good as it is in the EU.
And we say, with respect, that is entirely wrong. There is no basis in the structure of the GDPR for reading into...
Well, there might be it might be in the CJEU case law.
Well, I would, my lord, you have, I think, raised gently with Mr. Gill this morning or this afternoon. Where are these cases?
Well, I agree. There are none on the immigration context. No.
Exactly so. Nor are there cases, I say, that support the proposition that if you fall down on your Article 35 assessment duty, the consequences of that radiate out to taint whatever it is you have done.
Well, I said I'd give you 5 minutes. You've probably not had 5, but I will give you a little bit longer. Let's just take stock. Everyone can have a half-hour break. It may turn out to be a 3/4 of an hour break. Insofar as it's whichever length it is, can I invite you, you've probably started already, but it's helpful while everyone's here, to flesh out what the timetabling arrangements are, both to get to the hearing in April and to manage the hearing in April. I am aware that there is an issue which you won't be agreed on, or see some of you aren't agreed on, which is whether we're talking about only a 3-day hearing. But for the moment, you've got to work on that assumption and on a without prejudice basis. But it would be very helpful to me when we've finished on this point, heard Mr. Ahmed briefly, if I could be told how far you have got on the outlines of a timetable, as I say, not only for the hearing, but for getting to the hearing. If you want my steer on any points, I will then give them. I will then hear anyone who wants to protest about the length of the hearing as a self-contained point. And I'll have a few things to say about bundles and so forth. But that's the broad agenda. I'm sorry the day is taking so long. It probably could have been predicted from the start. I can't go on beyond 4:45, but I am optimistic that we will get everything done in that time. Thank you.
Bye.